Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elawvate.net, ELAWVATE.net, or go online to elawvate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elawvate.net or fill out a case workshop request at elawvate.net. And Rahul and I will look forward to chatting with you soon. This episode of the Elawvate podcast is brought to you by Filevine. Filevine has a software program called Lead Docket, which is the gold standard for managing your new case intakes and leads, your Glengarry leads, your Glenn Ross leads, and all of your other leads. So check them out at Filevine and manage your leads. We're also brought to you by Steno. Rahul, you guys work with Steno?
Steno is the best in court reporting services, not just in court reporting services, but even some of their technology tools. We're talking about AI a little bit on this podcast, and their transcript genius, where they can summarize and take interrogatories based on deposition transcripts, is so useful. If you haven't tried it, definitely try it.
We're brought to you by Hype Legal. Hype Legal does digital marketing, web development for trial firms. It's owned by our good friends Micah and Tyler. They recently redeveloped our firm's website, so you can check our website out. If you like it, give them a call, and they can help you out too. And finally, we're brought to you by Expert Institute. Rahul, you guys work with them, right?
We both use Expert Institute because you always need to be cutting edge in the experts that we use in our cases. Going to the repeat experts every single time is going to make you a lesser lawyer, and you always want to keep up, and the best way to do that is with Expert Institute. Welcome to the Elawvate podcast. I'm Rahul Ravipudi.
I'm Ben Gideon.
Good morning, Ben. It looks like you're on West Coast time. You look amazing.
Rahul, I can finally relate to what it's like to have to get up and do this podcast at 6 a.m. It's a little rough for me, to be honest with you.
I actually wasn't sure if you were going to make it, but you're here in LA to take Josie out to look at a couple of colleges, USC, UCLA, the ultimate rivalry.
We're heading to USC later today, maybe stopping by the Panish offices in downtown LA.
That would be amazing.
Maybe.
I'm hoping that happens.
But so we were in Ithaca, New York yesterday, touring Cornell University, my alma mater. It's really weird to go back to your college after 33 plus years and see all these areas that I spent a lot of time in Ithaca. I was there for many summers during college and just kind of got into the community quite a bit. And to go back there at a different time in your life is just a weird experience, because when you were there before, everything was in front of you, everything was potential. Now that's all gone for the most part, and but you're looking at the same potential through the eyes of your daughter who's about to start college. So it's kind of an interesting experience.
What was your takeaway from that?
She didn't want to go to Cornell. She wants to be in a city, so I think LA may be a better fit, but we'll see. I don't know how one chooses where to go to college. It seems like a really hard thing to do in the modern era.
Yeah, it was much easier for me than it was for you. I only got into a couple colleges, so Riverside it was. That's
One
exciting.
thing I was a little disappointed when we arrived here. I didn't see any riots. I didn't see any fires. It just seemed like kind of a normal city and on a quiet street. What's going on here? I thought there was more action.
Well, what happened was JD Vance saved the city, according to him. It's amazing, amazing what he was able to do. And I say that with ultimate sarcasm. So
Yeah.
it's
We
crazy.
were walking around West Hollywood a little bit. I was trying to explain to my daughter the concept of the gay bar. Initially, she was like, "What?" And then we walked past a couple of the bars. She's like, "Oh, I get it now." Such a scene over here.
No, definitely. Where are you staying?
My
Oh,
my friend
yes.
has a
Yeah.
place here, a home, and yeah, so they're not around,
Very
so they let
cool.
us use their home.
Very
So that
cool.
seems like enough inane banter to segue into our episode. It's a pleasure to welcome Chris Nace and Samantha Peters of the Nace Law Group to the podcast. Welcome, guys.
Thanks for having us.
Thanks for having
This is
us.
exciting.
Well, Chris, you're a seasoned veteran with your podcast, 230. Ben, a sports podcast with five guys on a Monday. You've got the voice for radio too, Chris. It's amazing.
Yes, that's right. Not the face for TV, but a voice for radio.
No.
That's for sure.
So, wait, do you have a sports podcast? Is that what I'm?
The SMQBs, yeah, with a bunch of guys who you might know: Toby Milrod, Brian Pope, Mike Phelan, Patrick Michler. So it's
Oh
all a
yeah.
bunch of trial lawyers. Yeah.
So give us your up to date take on our sports climate here.
Well, the most interesting thing right now is the debacle that is the WNBA. And how it's turned into full like WWE wrestling, right? I mean, they're like leaning into all the battles and Caitlin Clark and Angel Reese and all the rivalries, but it's like it's become like must see TV to see who they get in a fight with during a game at this point. It's I don't know. I mean, they're drawing eyes to it, and we're talking about it right now, so maybe that's the goal. But I think they could probably do a little better than that to advance the game.
It's turning into hockey.
Yeah, that's right.
Yeah, I was
Yep.
surprised to see did you watch any of the NBA finals this year?
A little bit. Yep.
Yeah, you may be one of the only ones, and because apparently the ratings were quite low, which you I guess would expect given the small market teams. But I thought it was pretty good, high quality brand of basketball. But I wonder where I mean, it may be that the WNBA is going to be eclipsing the NBA soon. The
Right. No
trends
kidding.
continue in the direction they're headed.
Yeah, no kidding. Well, the NBA's got their issues that three of their big stars are all going to be out next year with Achilles injuries. So it'll be an interesting season to see what happens. That's for sure.
Yeah, as a Celtics fan, I'm
Well,
not
that's a
too.
perfect example of that concept of causation and correlation. Didn't all the players wear the number 0 also?
Yes, yes. Isn't that wild?
Yeah,
Yeah. So
crazy. So, Chris and Samantha, thanks for joining us. Just kind of taking a step back, Chris, as a former AAJ president and leader of the plaintiff trial bar. One question, just as we go through your background, for the listeners and for those who want to get more involved, not just in the practice of being a trial lawyer, but in becoming a leader in the community. Love to hear more about your journey towards that path.
sure. Well, I'm not actually a past president of AAJ. I'm on the ladder right now.
Oh, awesome!
But
Even
I
better.
did. My path was blazed for me by my father, I would say, because he is actually or was a past president. He was president of then ATLA, 93, 94. And I started going to ATLA conventions in 1986 when I was 10 years old. And at some point, you know, I don't know, I guess I was indoctrinated or brainwashed, whatever you want to call it. But going to those conventions as a kid and seeing the speakers and hearing the stories of the clients, I pretty much always knew that I was going to go to law school and thought I'd always represent people. And after practicing for a little bit, doing patent litigation at a firm, I left that firm and joined my dad's practice and got to cut my teeth trying a lot of cases where maybe we had settled out with 2 or 3 parties and there was one party not so culpable, but, still had an expert to support it left, and rather than dropping them, my dad said, "Go try the case." So I tried a lot of very challenging malpractice cases with a lot of empty chairs, but got that experience, and then along the way, just getting involved in the bar and in trial lawyer groups was always just part of what we do, you know, as a family, as a law firm. My dad was twice president of the DC trial lawyers, so I went that route and served as president of the DC trial lawyers. But leadership is really important. There's so many vulnerabilities to our practices. And without our organizations and without what we do, our clients would have no recourse. I was talking to a member of the District of Columbia City Council the other night about some bad tort reform that we're facing and that we're trying to keep back right now. And I said to him, I said, this is not a trial lawyer issue. This is not about us. We're going to all be fine. This is about the people who are going to be most egregiously injured, who will suffer and who will fall onto the shoulders of taxpayers moving forward if we do this. So, to me, serving in AAJ now as an officer, I'm the treasurer now, going to secretary at the annual convention this year, and also being involved in DC trial lawyers still, it's really critical to protecting the right to trial by jury and protecting citizens. And if we don't do it, if we as lawyers don't get engaged and do it, who's going to? Right? Nobody's talking to legislators and explaining what happens to our clients if we're not doing it. And so I'm happy that Samantha is going on to the board of the DC trial lawyers now, or I guess you're on officially at this point. So, it's something that's important to our law firm to be engaged.
So, Samantha, tell us a little bit about yourself. We learned offline that you and I have the Maine connection, but how'd you go from Westbrook, Maine to the practice of law in DC?
Yeah, so I moved down to DC for law school. I went to George Washington University for law school. And while I was in law school, I started working for a PI firm. And that was always an area I was interested in, PI, medical malpractice. It kind of became the course I just followed thereafter. I've worked at a couple med mal firms before I found my way to Nace Law Group. And I've been there for 3 years now. So I've been in practice for about 10.
So, how did you get interested in plaintiff side practice and particularly medical malpractice?
Yeah, so when I was younger, my dad passed away really suddenly. And it's a long story, but at the when 911 was called and the ambulance was dispatched, the EMTs got out. They took out the defibrillator paddles to resuscitate him, and they didn't work. We later found out through somebody who kind of blew the whistle on it that the maintenance log for the equipment on that ambulance had been hidden because it hadn't been checked. And so the defibrillators on that ambulance hadn't been checked before the run or after the last run. I was little. I don't remember all the details, but we ended up having a personal injury lawsuit for the failure of the town to sort of properly check their equipment. And there was a notice period issue that we had at the time. You had 6 months to give notice to the city if you wanted to sue. And we were just outside of that period. And so there was an appeal. And I remember watching as like a 10-year-old this appeal get argued and just being so fascinated by the whole process and just feeling like I was in an important place where people could have their rights vindicated, but not totally understanding what was going on and really just wanting to be able to understand it better and be able to help people in the same way. And so that really sparked my interest in this particular area of law, being on the plaintiff side. I can't imagine. I've never been a defense attorney. I can't imagine being on that side. But yeah, it just really instilled in me that there's a system out there if it works well that can help vindicate people and their rights, and hopefully get them a small amount of justice after a huge loss. So that was sort of what started me on down that road.
So,
In that
Chris, I want to ask you
appellate argument,
the
sorry, I just wanted really quickly here. Did they give the forgiveness on the being late on the filing?
They did not, and my 10-year-old self really thought it was the lawyer's fault, but I'll forgive him.
I think it was probably was the lawyer's fault. I hope I wasn't involved in any way in that.
I don't think so. I think you're probably too young.
Yeah. So, Chris, I want to ask you the question I've been waiting to ask you now for many months since we booked this podcast episode, which is how do you pronounce it? Daubert?
Ah,
Daubert?
that's really funny. It is Daubert. Um, we recently had so the a lot of people who listen will probably know this. My dad represented the Daubert family. I was actually in the Supreme Court at the hearing or at the argument on the Daubert case, and we had a little reception back at my dad's office at the time with the family. And to show you how like life comes full circle, 2 years ago, I guess, was the 30th anniversary of Daubert. And I happened to be president of the National Civil Justice Institute at the time. And one of the things that NCJI does annually is a forum for state appellate court judges. And it's only judges. We try and present an issue that's important in the law. We have about 150 to 200 appellate court judges who come. And so the 30th anniversary of Daubert, I invited Joyce and Jason Daubert to come address the judges. And it was pretty wild after 30 years to kind of cross paths again with them. But as you can imagine, that was the first question that came up at the lunch that day. And Joyce, Mrs. Daubert, said, "Well, it is Daubert, but I forgive anybody who says Daubert." And so she blessed it either way, I guess. But yeah, it's I hear that question a lot.
Did your father understand what the significance of that opinion would be at the time?
Well, I think so, but you know what gets lost on people is that that was a 9-0 win for what the plaintiffs were advocating for, right? At the time, the idea was that 702 was more open than generally accepted in the field. And so the idea, at least the argument was, look, 702 says this is what it has to be reasonable and reliable, and you have to have sound methodology, but that's more forgiving than generally accepted. And we're going to let experts come in, explain their opinions, and let juries decide the question. Of course, what happened, and ironically, is Jason Daubert never had a Daubert hearing because after the Supreme Court laid down the new standard and said Rule 702 did apply, what happened was it went back to the Ninth Circuit, and the Ninth Circuit applied the new rule and excluded the plaintiff's experts. And actually, it was very compelling to hear Joyce talk about, this was a woman who was an AP Spanish teacher in public schools in California. And she had lined up all her substitute teachers, which is not easy when you're teaching AP Spanish, and had gone out and bought court clothes to go to trial. And on the morning they were supposed to start trial, that's when the trial judge initially struck the experts and dismissed the case. And so even 30 years later, Joyce lamented the fact that she never really got her day in court. But to hear this individual, I mean, she went through quite a bit to decide to bring a lawsuit. Her father didn't appreciate the idea. It wasn't something that was popular, obviously, and we hear that a lot in what we do. But she really, it stuck with her that she never really got to tell her story to a jury. And yeah, people don't know that Jason Daubert never had a Daubert hearing in front of a trial judge. And here we are 30 years later.
Yeah, it's interesting that the idea of it was to be more expansive, to allow experts that had novel opinions that were not already established to testify, but it's been obviously used to exclude experts because their opinions are not up to whatever the standards are that are required. But obviously an enormous impact and something you probably deal with regularly in your medical malpractice cases, right?
Seeing more of it, that's for sure. Yep. Yep.
Well, we know who to blame.
Yeah, that's right. Fair enough.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at PSRplaybook.com and learn from the best.
So you guys had recently had a great verdict trying a case together. Do you guys want to tell us a little bit about your case and how it came together and the trial?
Yeah, Samantha, why don't you tell a little bit about the facts? You took the lead on working it up for us and getting it ready for trial.
I knew you were going to say that. Um, yeah, so the case involved a 43-year-old husband and father of three minor children, and then he had one older child from a prior marriage. He had looked at bariatric surgery a couple times in his life and had finally decided to go forward and do it at this point. But one of the things that he had to do to get the surgery was a pre-screening clearance endoscopy just to make sure everything was okay. It's supposed to be a super quick procedure done under twilight anesthesia. And so he went in for that, and while he was in there, his oxygen saturations and all his vitals essentially started just steadily going downhill, and the anesthesiologist just didn't react, didn't really do anything in response, didn't have the surgeon stop the endoscopy. And Chris can talk a little bit about that later because the trial testimony differed substantially from the deposition testimony and the medical records. But yeah, he essentially didn't ask the surgeon to stop, didn't intervene really even when the surgeon stopped beyond just putting like a mask on the guy. It seems like there was a delay in him calling for help since he wasn't able to intubate or do anything else to help with this guy's oxygen. And so the decedent ended up passing away after he suffered a severe anoxic brain injury from not having oxygen for about 10 minutes, maybe more. He coded, there was CPR, and he had about a 10-day ICU stay following that. One really sad part about it was his youngest daughter was only 4 months old at the time, so she has no memories of her dad. And just a really sweet family. He was a public school teacher. His wife was a social worker and still on maternity leave. So it was just all around a really sad case for a really, really nice guy, and it just didn't have to happen.
Wow. You don't hear about people dying from endoscopy procedures very often. Um,
Yeah.
so tell us a little bit about how the case went in the trial.
Well, the wild thing about the case, you know, every trial surprises you, right? I mean, there's nothing you can plan all you want, and there's always something odd. But the medical records and the timeline, like, it's documented when the procedure started, when anesthesia started, when the endoscopy started, when it ended, and when when he finally left the procedure room in like 10 places in the records, right? I mean, maybe exaggerating a little bit, but all the times are the same through the record. And in discovery, the doctor adopted all those times. He said maybe a minute off here or there, but these times are accurate. They're right. His testimony was pretty locked down on that in deposition. Well, lo and behold, we get to trial, and the first time we find out this is how they're going to defend the case is in the opening statement of the defense, where they put up a timeline, a very slick, well-produced timeline. We've all seen them where you click on a box and it pulls up, something, and click here. Except this one didn't pull up any medical records. It just had their interpretation of the timelines. and it was vastly different. And of course, like any medical case where there's a timing issue, the defense always tries to shorten that window where something could have been done, right? They want to go from, 10 minutes where nothing was happened to 3 minutes. And the only way they could do that was to change the times from the records. So they put up this slide and timeline that I'm not sure that they showed a medical record during trial. And they kept coming back to this PowerPoint slide with their timeline on it. And, we're looking at each other at counsel table going, what? How are they doing? I mean, the deposition testimony is solid on this. And when we got to closing argument, I talked about the script that they had written for the trial and how they kept coming back to their script and they never showed a medical record in the case. And that was largely how it was defended. Samantha did a great job crossing the defendant on this. And, his testimony was, and Samantha, tell me exactly, but there were 2 points in time where he said at trial for the first time, I remember looking at the clock when this was happening and it seared into my brain. And I'll never forget looking at the clock, at this point in time. And that's how I know. And it was like, well, was it seared into your brain when you gave your deposition? Right? I mean, Sam, do you want to say a little bit?
Yeah, it was shocking. I've never seen such a 180 on testimony before from his deposition to trial. I had a planned cross, obviously, and your cross never goes exactly according to your plan, and a lot of it is just off the cuff. But I essentially just scrapped the whole thing because his trial testimony was so remarkably different from his deposition testimony and the medical records that I had no choice but to just go off the cuff for essentially the whole thing because we had no idea this was coming. On the timeline they used rather than the medical records, some of the numbers they were using were just wrong. They were also selectively choosing values. So he had a pulse ox on his finger that was capturing some of the, heart rate, diameter, and then he had like a blood pressure cuff on, and then he had the EKG stickers. And they talked a lot about how they thought the pulse ox on the finger that was measuring the heart rate and his oxygen level was askew, so that's not trustworthy. But then where they liked the number the pulse ox was giving on the monitor better than what the EKG was giving for heart rate and things like that, they would only put up the pulse ox number or only put up the EKG number, whichever number they liked better. That's what they would use on their and it wasn't consistent. So they were switching back and forth. Some of it was wrong. Some of it they tried to claim it was like an evidence summary, but none of that was. Some of it was just stuff they were inventing at trial. So yeah, he said that it was seared into his brain that the surgery actually stopped 2 minutes prior to when the records say it stopped, even though in his deposition he said, yeah, give or take a minute, but that's about when it stopped, based on this certain thing. So, they were trying to get rid of this criticism we had that he should have told the surgeon to stop. He had it seared into his memory about certain moments in time when maybe it was his heart rate, Chris. I don't remember
Mhm.
exactly what value it was, but I remember seeing, 42 on the screen. And then the next minute it also said 42. And that's seared into my memory. And I'm like, once again, was it seared into your memory at the time of your deposition? And just contradicting the medical records. He was making weird faces when he was testifying to it. I mean, it was just a bizarre turn of events. And I think that they didn't do themselves any favors by having this doctor change his testimony. I mean, there was no wiggle room. This wasn't like something where you could be interpreting the testimony differently or a question differently. This was just 100% contrary to what he'd said in material ways on multiple points throughout. So it was surprising to say the least.
I'm so confused by this defense strategy of putting up misleading slides in an opening statement and then double downing on it with flipping the script on the testimony. Like, who was the mastermind behind this defense approach?
Well, it's funny you ask that because the case, these cases, they how long they take and how they meander through the justice system sometimes. I think the defense had 5 lawyers touch the file at different times. Somebody retired, somebody went on maternity leave.
Somebody
There were
else
a
went on
lot of
maternity leave.
somebody else went on maternity leave, right? There was a lot of different defense lawyers in the case. And, and actually the case started with a different lawyer in our firm. My brother had been with us and he had, initially worked up the file until deposition discovery really got going in it. So I don't know. I mean, I'd love to ask them, what were you guys thinking? Like, why did you, I mean, the records were bad for them. And you know, they they had the surgeon who did the endoscopy come in, and he was pretty locked down on his position, but he tried to give a little bit to them. And so I don't know. I just don't know why they did it. I do think it was a strategic mistake for them. But in closing, I spent a good amount of time talking about medical records. And I actually sort of set it up with their expert, which that's another story. I'll come back to that in a minute. But, the idea that medical records are legal documents and that they're documents that are meant to translate from one provider to the next so that people understand what's happening with a patient, and that these are kept for all sorts of, credentialing purposes, et cetera. And I really impressed upon the jury that those records have to mean something. They have to mean something, and you have to be able to rely on them. And you can't just come into a courtroom and say the records are wrong, particularly when the burden of proof is more likely than not. And that's our burden of proof. And it was important to me that the jury understood that you can't take those medical records for granted, that they are not something just put together after the fact that don't mean anything, that could be off here or there, that they had to count for something as evidence in the case. And I think ultimately that was important to them.
How do you, in working up the case, get that concept across as a rule of the road with defense depositions? That it's these medical records are legal documents, and the substance within them need to be accurate.
Well, I always tell people, if you want to like start a cage match, throw into a listserv, a malpractice lawyer listserv, and ask if it's okay to depose or not depose defense experts, right? Like people like go to war on their position on that. We generally do not depose defense experts in our cases. In my experience, you just help them learn the case. It can be a little scary going up, particularly when at trial they change their whole theory of the case. But the expert that testified at trial, their standard of care and causation expert, was quite a guy. Our expert had testified by recorded testimony, by video recording, which we did in advance of trial. It wasn't ideal, but he couldn't be there. We didn't want to lose our trial date, and it just, it was a decision we made to do. They had the same issue, but they elected to present their expert by Zoom live, which technically worked fine, except he was sitting in the on-call room at his hospital. He was visibly texting and emailing during his testimony. He took 2 phone calls while I was cross-examining him, like
Live on the
without
record.
right, without asking for a break. Just answered the phone and talked about the patients. He had 2 or 3 times where an intern or another doc came in and asked him questions about a patient on the record in front of the jury. So you have this strange juxtaposition because of the way the courtroom was set up, where he can't see me. So I'm standing at the podium, which, I usually don't do that during a cross-examination, but because of the microphone setting, I had to stay stationary. And I can see a screen of him, but he can't see me. And I'm standing there sort of looking at the screen and looking at the jury the whole time. And to say he was arrogant doesn't do it justice. I mean, we've all seen arrogant experts. This guy was at the top of that list. And so with regard to the records, you know, you just when they're so arrogant, that they're ready to just brag about something. You've been doing this so long, you make entries into the record. I'm sure you never make a mistake when you make an entry into the record, and that's because other doctors are relying on it. And if you make a wrong entry, someone can get hurt. I mean, he went through the whole thing. He was so ready to tell this jury how perfectly he practices medicine. I don't think he knew that they were going to change the timeline. I'm not sure he was familiar with that.
Well, Chris, one thing that I thought was probably one of the most phenomenal gifts we could have been given was they were showing him their timeline, which, by the way, we had never seen before trial. They went to move it in as an exhibit. We had to ask the judge, can we at least see a copy of it? Like, we've never seen this before. And the judge, over our objection, on a number of bases, allowed them to get it in as an exhibit. So we don't have it uploaded on our computer. So when Chris and I are trying to juxtapose their exhibit against the medical records, we're having to let the witness use the paper copy in front of them, while we're trying, on the big screen to show the records. So, I mean, we were at a disadvantage there. But my favorite thing that he did was he had, again, not the medical records in front of him, but just the timeline. And he, at one point, when the defense attorney was doing his direct, and she didn't try to fix this at all, but he said, and that number is from the EKG, which is far more reliable than the pulse ox or something. And he had them backwards. And so it was where he liked I'm retelling this wrong, but basically whatever was on their timeline was only one of the values, and he basically said the opposite of what they'd been trying to impress upon the jury. And so Chris had plenty to work with there, being like, and you'd go with the EKG number, right? And okay, great. And the EKG number right here is this number, right? And that's a lot lower than the one on the pulse ox. And you agree that's more reliable. And so I think they just gave us a gift on that, because he was so arrogant, not looking at the medical records, just using their timeline, and just assumed they'd taken the EKG numbers and not the pulse ox numbers, when in fact the EKG numbers, we agree, were probably more accurate, and they were way more damning than the pulse ox, which the pulse ox numbers also were not good, but they were better for them. So that was one of my favorite moments of arrogance, him just confidently asserting this. And the defense attorney who just asked that question and got that testimony in return just was dying inside at that moment. So it was a lovely gift.
The other thing that I was able to do with him was, so there was an issue in the case of why the anesthesiologist didn't try to intubate. When things started going badly, basically all he did was mask and bag the patient
Just held his patient's face for
yeah
8 to 10 minutes. All he did was this.
While the surgeon squeezed the bag, I guess, and it was 8 to 10 minutes of just mask and bagging. And his explanation was, because this was a large man with obstructive sleep apnea who he knew might obstruct, he really needed to have a glide scope in order to intubate. So of course you have your blades you can use to intubate. You have the laryngoscope, which is a little more advanced, and then I guess the state of the art is the glide scope. And not every procedure room has a glide scope in it. So the defendant testified more or less that this was such a complicated airway that he needed the glide scope before he could try to intubate, and he was waiting on that. Well, the defense expert, again, kind of playing on that arrogance. I walked him down, doctor, you trained, at this school, then you went to this hospital. I think he might have been in the military maybe at one point. And, I built up his credentials, and I said to him, I bet you that you could take a blade out no matter how dangerous an airway is, how complicated it might be. I'll bet you could just intubate with the blades, no problem. And he said, of course, any anesthesiologist should be able to intubate with the blades. I said, I'll bet you see these young doctors coming up now, and they don't know how to do it without having the glide scope available. And he said, oh, it's terrible. We have to teach them, how to use the blades. But you absolutely, as an anesthesiologist, have to be able to intubate someone with a blade. You can't always have a glide. And he just walked through the whole thing. And it was great in closing then to be able to say to the jury, listen, this doctor froze and he didn't know how to intubate this patient. Even their experts said, this is anesthesiologist 101, being able to use the blade. So just kind of sensing that arrogance, um, that was as good a tool as having had a deposition of this guy, for sure.
The other anesthesiologist that eventually came in the room and intubated the guy, um, he testified at deposition that when he got into the room, he immediately takes the bag over from the surgeon who was bagging, and he says, "Within 1 or 2 pumps of the bag, I know this guy's not getting oxygen and we need to intubate." So, I looked at the defendant doctor and said, "We need to intubate," and he agreed. And then he's like, I was thinking he was about to do it, but instead he said, "Would you like to intubate him?" And so this doctor, this anesthesiologist who came in said, "I didn't really have time to question why he was asking me this. It was an emergency and this guy needed oxygen, minutes ago. So I just did it." And I was like, "Did you have any trouble getting it in?" And he was like, "Nope, it was a perfectly easy, smooth intubation. There was no issues with like his neck circumference causing an airway issue." That guy conveniently had a delayed deposition because he had been sadly diagnosed with cancer and was going through treatment. By the time of trial, he was fully in recovery. He was doing great, but miraculously, he happened to be out of town just perfectly for the dates of our trial, so we couldn't get him served. So, interestingly enough, they worked for the same employer. I'm sure there was no communication there about trial date issues or anything like that. But yeah, he was not able to be called live, and this is on me. I should have taken his deposition by video, but he was a local doctor, and so we had to read it in. We had to read in this guy's testimony, but it was pretty damning. And he wasn't trying to hurt this anesthesiologist by any means, but there was just so little he could do that was helpful if he was being honest. And I think he gave honest testimony about, "I didn't ask why. I didn't want to know why, but I just did it. I don't see any reason he couldn't have done it, but I'm not, second guessing him." So that was another interesting wrinkle, was this bizarre testimony from this guy's coworker who did come in and sort of at least attempt to save the day very quickly. Yeah, he was not available for trial. So that was interesting.
Can I go back to that debate about whether to depose the defense experts? Just talk a little bit about, without the benefit of that safety net of the deposition, how does that change your approach to your trial cross-examination? Are you a little bit more conservative? Are you going based primarily on the four corners of the record? Are you taking some leaps of faith, doing more background research? What's your approach there?
So for me, I think you have to pick a few points that you want to make with the expert. What are 3 or 4 points that I'm going to be able to control this testimony on? And then I really think on breaking down your questions is incredibly important to how you control the witness. It's very easy to come up with 2 or 3 questions that you think are going to help you get your point, right? But if you go back and really look at those 2 or 3 questions, you can probably come up with 12 to 15 much smaller questions that really lock the expert in, and you don't let them wiggle out of it. So when I'm preparing for that, I'm always thinking, what is the assumption in my question that I first wrote out? What is the assumption that he's going to be able to walk away from? And then I go back and try and tighten that up. And then look at those questions and say, okay, what are the assumptions in those questions? And write more. So you really have to, and I don't really script out a lot. That's not really, but at least in thinking about it and preparing certain parts of it, I absolutely will script out 10 to 15 questions per point that I want to make that I don't think an expert can get out of. And if I've thought through those the right way and have the record to point them to when they try and, wiggle out of something, more times than not, you get the answers you want on that. But it definitely makes you say, and maybe it makes you a little more humble. It makes you say, I'm not going to tangle with this expert on issues A and B, because I don't know what he or she's going to say, and if they say something that I don't know how to, I don't want to get stuck there. So I'm going to leave those issues over here, and I'm going to focus on what I want to focus on, which are C, D, and E. And so I think what I always say to Samantha is, get in, hit your points, and get out of there. Because I don't think juries have a super long attention span anymore. They don't want to see a 2-hour cross examination of an expert. And in most cases, I mean, all this is case and fact dependent, of course, but in most cases, they want to see you up and down in 15, 20 minutes. And you can do that. You can be efficient and make your points to use in closing in a short period of time if you're very, very tight in your questioning.
I agree with Chris on that. We often go back and forth too before trial where whether it's me or him doing the expert, we'll be like, you know, okay, if I ask this question, is there any credible way this expert can walk away from it? And so we'll kind of go back and forth on making sure that we're both on the same page at things that they absolutely can't say no to, or they can't say yes to, or whatever the fact may be, or they can't deviate from this value that's in the record because nobody's disputed it. And if they do, it would honestly be a gift if they did, because it's just so unbelievable. So we kind of go back and forth a lot on each other's crosses, just batting back and forth what we think their expert can or can't walk away from. I'm also a big fan of the background research. Whether I like to do this for all of us, so I will do my best to dig up every transcript I can find, every past CV, every listserv message, every you name it. We found an internet video of one guy in one of my cases where he was like selling a back massager and claiming to be an expert on that. And so, there's all kinds of stuff out there on the internet that you can find. And so some of that helps you lock down their experts, especially on things they like to get squirrely about, like, oh, I only do 80% defense work, not 97%. And, well, didn't you say in your deposition 3 hours ago, in this other case that you do 97% defense work? And then another thing we have in Maryland, the expert designations are really very skeletal, which in some ways is a gift when you don't depose their expert. Sometimes they're vague enough that they could basically get any testimony in and it would be covered. But sometimes there's very little detail, but just enough that you can argue, Your Honor, I didn't depose them. I don't have to depose them. I have a right to know their opinions from their expert designation. And this is what they said in their expert designation. They give all of 3 sentences on what this guy's going to say on causation. And then this guy says things that can't be categorized under that umbrella of, whatever sentence they put in there. And depending on your judge, you can sometimes get them boxed into their very weak attorney written expert designations, or their very brief pretrial or pre-suit reports that we have to do in Maryland. So that's sort of another benefit of not deposing is, if you depose them, there's no real argument that you're surprised by what they say at trial if it came out in their deposition, even if it wasn't in their designation. But if you haven't deposed them, you can say, look, this is what their designation said. That's why I didn't depose them, because it said this, and, that was fine with me. But now he's saying this. So that's, I guess, another benefit of not sort of auditioning their expert witnesses.
The other thing about their expert that, and again, I think this isn't anything like super, eye-opening or anything, but this was the kind of expert that I felt I could attack in closing argument, right? It's always, how do you treat these experts in front of a jury? But with his behavior on the camera, I felt that I had permission from the jury to attack him more than I would typically attack a witness in closing argument. And I said to the jury, I said, you saw what he was doing. You saw he was sitting there talking to doctors, talking to interns, taking phone calls. Make no mistake about it, ladies and gentlemen, he was double dipping today. He was getting paid to testify and he was working. He was doing both. This is a case where a 43-year-old father of 3, husband, father of 4 actually, is dead. And this guy couldn't come here to testify. And not only that, he couldn't not be working to give his opinions. And so, I might be a little too easygoing in the courtroom sometimes, but this time I felt like I could really go after him. Now, we did talk to the jury a little bit after, and at least one of them commented that, oh, he was very impressive. Your defense expert was very impressive. but the defense lawyers were standing there too, so I'm not sure how much I put into that. One other thing I want to say about our jury, this was a very weird jury for Baltimore City where this case was tried. Uh, in the DC area, most of us practice in multiple jurisdictions, and Baltimore City tends to be really the last jurisdiction where you expect to see a jury that we would all think is going to give money to a family, give a lot of money to someone. In Washington D.C., we end up with doctors and lawyers. There's always a lawyer or two on a jury in DC, mostly professionals. Uh, and we thought, this is Baltimore City. We don't try a lot of cases here. We're going to get the best jury we've seen probably since Sam and I have been working together. This is going to be fun. Damned if it wasn't the most professional Washington, D.C. jury, probably that Baltimore City's seen in a long time. But they
Educated,
were,
younger.
yeah, I mean, but they were great. And the first
Yeah.
thing they told us that they did when they went back to deliberate was on their own. I didn't prompt them, and maybe I should have, but they said, "How long is 8 minutes really?" And they did the thing where they sat in silence for 8 minutes trying to decide, because that's what I'd said in closing was 8 minutes before anybody did anything other than mask and bag this guy, and you have to try something, right? And they sat at 8 minutes and they said, we got to 6.5 minutes. And we all were like, wait a minute, come on, you got to do something else. So very smart, sophisticated jury that worked to our advantage.
I think, not to toot my own horn, but to toot my own horn, in the cross of the defendant, I realized what he had been saying in his new testimony that we were getting for the first time was essentially all he did the whole time was do a jaw thrust. So and they talked about how tired that would make your hands. It was bizarre. Like we were supposed to feel bad that he had to do his job for this patient. I'm not sure. But all he did was then do this jaw thrust and hold the mask on the guy's face. And this took a lot of restraint because I'm sure, as everybody knows, when you're up there, you really want to like land that final sucker punch. But, restraint is good. You should leave that for argument. And so I got the testimony out and I just was so happy it came out because I was like, Chris can hammer this on closing. And it goes with that point of sitting there for 8 minutes that. And I was like, and you just do the jaw thrust once, right, doctor? And he said, oh, yeah, it's a one-time thing. You do it to sort of help open the airway. And I said, and then you held the bag on, right? And he said, yep, I had I kept the jaw thrust and I had my hands on the bag. And I said, okay, so while you were in there waiting for help to come, this is how your hands were, right? And I was like, and you were troubleshooting in your brain what to do next, but your hands were like this. And he was like, yep, until Dr. So-and-so entered the room, my hands were like this. And so that set Chris up to say for 8 minutes, all this guy could think to do was hold him like his hands were like this. And so I think when the jury went back and said we were trying to wait 8 minutes and they're sitting there as the clock is ticking by, they're thinking, gee, you have a lot of time in 8 minutes to try to do something other than merely just I guess nobody can see me, but merely just keep your hands on the guy's face holding the mask down. Like that is literally all this man did for the conservative number of 8 minutes. We think it was probably longer than that, but
Yeah.
and so I think that was, the fact that they went back and sat there and tried to time it out. Honestly, that was brilliant. And Chris and I think we were both like, oh, we should have thought of doing, a timing exercise in this case. But I think that just really illustrated how much this guy did not do here.
And maybe we've buried the lead, but can you guys tell us the result? What was the verdict?
Well, the verdict was the jury awarded $1.5 million in economic loss. We always give a range when we present economic losses based on certain assumptions so that the jury can decide, right? We want them to feel like we're not just shoving it down their throat, that they can decide how long the guy would have worked, if he would have had this promotion, et cetera. They gave, I guess, sort of in between our range on the economic loss. And then they gave $6.5 million pain and suffering, non-economic loss to the family for losing their husband and father. And our client had just done an outstanding job,
A good job.
in Sam's direct of her, which really shocked us because when I first started talking to her before trial, I thought we are done. She is, she just wasn't an outgoing person.
Introverted.
Yeah, it didn't seem very likable initially, but boy, she was awesome. Unfortunately, in Maryland, we have fairly egregious caps on damages. So the result was cut down quite a bit by the cap.
Yeah, I really do want to toot the client's horn though. So she is a lovely human being, and if you know her well, she's lovely and wonderful, but she's more introverted. She processes things internally. She's like a thinker. She really would think through a question, which is great. You want somebody careful in day-to-day life, and but when you're giving a deposition like she did in our case, the pauses where she'd stop to think about something, it sort of just didn't come off well. Like it came off almost cold. And I think the defendants were really banking on a jury just not liking her. Thankfully, over the years of, dealing with the case and chatting with her more and more, I was like, she's got a really warm, wonderful, amazing side to her. And we just have to be frank with her and get it out to the jury. And so at one point I said, look, you're very stoic, but this is the time, like you got to put that aside. Like I need you to be warm and friendly. And she made a joke about her RBF. I don't know if people know what that means, but I won't say it out loud for those who don't, but her resting, what face. And she made a joke and she was very receptive to the information. And so I practiced with her, like, give me really specific anecdotes about him. Let's work with those. And, she told this sticks with me because I just thought it made him such a human, her husband, such a human being. She said, he was a larger black man, big, tough looking guy. But when he laughed, and the first time I heard him laugh, I was absolutely shocked to hear he had this like high pitched little girl giggle. And every time somebody would look at this man and then hear him laugh for the first time, they would start dying of laughter because you're like, there's no way that laugh is coming out of this guy's body. And she had like a happy, wistful face on when she gave this very genuine testimony to the jury. And she had a lot of really good, specific like feelings. And she'd just done a really hard work beforehand of thinking through these things, running them by me. And, I didn't want her scripted by any means, but I did want her to have thought of these things beforehand. And she was so fantastic. A monkey could have done her direct exam and it would have done like this was the easiest job I could have ever had in my life. Like we were blown away by how, and I knew she was going to do well at that point because I'd gotten to know her and we'd been frank enough to say like, look, you're introverted, you're wonderful. That comes off fine in day-to-day life, but this, like, you've got to be warm. You've got to, put that outgoing side of yourself out there. And she just did such an amazing job at it. And, she's probably 90% of the reason that we got the verdict we did. She just did such a wonderful job. So
Yeah.
I need to give her credit for that because she did a great job representing her whole family.
Well, I don't do any medical malpractice cases, and anytime I hear a summary on a case, I get bogged down in the big words and the numbers and the timing of issues and things like that. But just hearing how you guys seized on every opportunity and converted everything into really simple issues that a layperson can look at and go, okay, this defendant really screwed up here. And just want to highlight that the real trial lawyering here, where you probably walked into that courtroom, an opening statement, thinking that the case was going to get tried one way, and then we're ready to pivot based on the opening statement. It's just fantastic to hear how you did all of that and how you were able to help your client through that. So thank you for sharing, and really well done.
Oh, thank you. Thanks for having us.
Yeah,
Thanks for
thank
having
you.
us.
Thanks for doing it, and congratulations on your case. And good luck as the
Thank you so
next
much.
or
Thanks, guys.
future
Thanks, guys.
president of AAJ, Chris.